universal injunction.
I'm sorry. Here,
Go ahead.
Here, there's a discrete identified group on one issue. Does citizenship mean, are you born in the territory of the United States, or does it mean, are you loyal to someone else, which is your claim, or are your parents loyal to someone else? So that's no different than what happened in a Bill of Peace. The United States is bigger, so it extends more broadly, but it's still an identifiable group on a discrete, singular question.
Your Honor, I'd say three things in response to that. First of all, our primary contention is that the citizenship clause related to the children of former slaves, not to illegal aliens who weren't even present as a discrete class at that time. But more fundamentally here, as to the issue of the Bill of Peace, there are critical differences. The Bill of Peace was a binding judgment that would bind absent class members. Here we have the asymmetry.
Well, here class actions don't bind anyone who opts out. So class actions are not like bills of peace.
I would think that a Rule 23b2 class action, which would be the relevant analog here, would be one that would be binding on absent class members and would not have the same notice and opt-out procedures. And more fundamentally, that sort of argument that there's a commonality here among, all the people who purport to be affected by this is the sort of argument that's made in class certification.
So can I ask you a question? Your theory here is arguing that Article III and principles of equity both prohibit federal courts from issuing universal injunctions. Do I have your argument correct?
We argue both of those. And
you argue both of those?
Yeah.
If that's true, that means even the Supreme Court doesn't have that power.
The Supreme Court would have the authority to issue binding precedent nationwide. But
we couldn't enforce it against universally, is your argument.
If there was a decision that violated the precedent of the court, then the affected plaintiffs could get a separate judgment.
And that means you're talking about the hundreds and thousands of people who weren't part of the judgment of the court. They would all have to file individual actions?
Not necessarily.
Or a class action.
A class action would be
Isn't that makes no sense whatsoever.
Respectfully, we believe that.
Well, what was the purpose of the Bill of Peace if not to settle a legal question finally? And if even the Supreme Court doesn't have that right and must invite hundreds of thousands of lawsuits, what are we buying into?
If a set of claims satisfies the rigorous criteria of Rule 23, Rule 23 is the modern analog of a Bill of Peace. We have something very different here.
No, we don't, because the argument here is that the President is violating not just one, but by my count, 4 established Supreme Court precedents. We have the one ARC case where we said fealty to a foreign sovereign doesn't defeat your entitlement, your parents' fealty to a foreign sovereign doesn't defeat your entitlement to citizenship as a child. We have another case where we said that even if your parents are here illegally, if you're born here, you're a citizen. We have yet another case that says even if your parents came here and were stopped at the border, but you were born in our territory, you're still a citizen. And we have another case that says even if your parents secured citizenship illegally, you're still a citizen. So as far as I see it, this order violates 4 Supreme Court precedents.
Yeah,
and you are claiming that not just the Supreme Court, that both the Supreme Court and no lower court can stop an executive from universally from violating those holdings by this court.
We are not claiming that because we're conceding that there could be in an appropriate case.
Only a class. Only
Can I hear the rest of his answer?
A Rule 23 class action. And then the more fundamental point as to all those Supreme Court decisions you referred to.
So what do we do temporarily?
Temporarily, the court may issue, the lower courts may issue injunctions that remediate the injuries to the plaintiffs that appear before them. Lower courts, in appropriate cases, may certify class action.
So when a new president orders that because there's so much gun violence going on in the country, and he comes in and he says, I have the right to take away the guns from everyone, then people, and he sends out the military to seize everyone's guns, we and the courts have to sit back and wait until every named plaintiff gets, or every plaintiff whose gun is taken comes into court.
In appropriate cases, courts have certified class actions on an emergency basis. We found at least 4 cases in recent years where that was done. But more fundamentally, we profoundly disagree with the characterization of the merits. This is now fully briefed in the Ninth Circuit in case number 25-807, where we describe how that characterization of the holding of Wong Kim Ark and the other decisions is profoundly incorrect. And that
still have counsel. Could I ask you about a different type of case that has broader impact than on the particular claimant? Like